Welcome. I am the President of Securities Arbitration, commentator Richard P. Ryder. SAC will be your host today. SAC strives to be a pro-arbitration, party-neutral force in its dispute resolution activities. What we hope to accomplish in this and subsequent podcasts is to stimulate thinking about specific topics and issues of interest in securities arbitration, and to do so by bringing together people who are knowledgeable about and influential in the securities arbitration industry to discuss these issues and offer their personal insights and opinions. Listeners should please keep in mind that while our guests work for and represent various firms and organizations, their views, as expressed in this podcast, are not necessarily the views of those organizations. To introduce our guest speakers and lead them in today's discussion, we've invited George H. Friedman to be moderator. George is an ADR consultant and SAC Board of Editors member. He retired in 2013 as FINRA's Executive Vice President and Director of Arbitration, a position held from 1998. Before that, he held a variety of positions of responsibility at the American Arbitration Association, most recently as Senior Vice President from 1994 to 1998. For the last 19 years, George has been an adjunct professor of law at Fordham Law School, teaching arbitration. He serves as chairman of the board of directors of Arbitration Resolution Services, Inc., and is the principal of George H. Friedman Consulting, LLC. George holds a JD from Rutgers Law School, is admitted to several bars, and is a certified regulatory and compliance professional. George, thanks to you, and thanks to our panel for being here today.
Thank you, Rick. First, we'll move on to some legalities. Unfortunately, we have to do this. This is a long disclaimer. I would tell you to pay attention to this part. Don't steal it because we're all lawyers here. Let's move on now to the third slide, to the next slide. The FINRA Arbitration Program, which was the first in the securities, FINRA Mediation Program, which was the first in the securities field, is celebrating its 20th anniversary this year. And for that, we credit Ken Andrushek, the Senior Vice President of FINRA Dispute Resolution, who was the moving force behind creation of the program. Now, over the last 2 decades, some 17,000 disputes, 17,000 have been referred to the FINRA Mediation Program this year, over the course of the program. As we enter this year, the program is at a bit of a crossroads. The number of staff dedicated to mediation has declined. Competitors have emerged in the form of dispute resolution providers and even mediators themselves. Now, in this program, we've gathered experts and practitioners in the securities mediation field. We're going to discuss what we think the future holds for FINRA's mediation program, and then to make some recommendations to the recently formed FINRA Dispute Resolution Task Force. It's a fast-paced program. We're going to move quickly and with some level of crispness, but we feel we will cover the topics in an appropriate manner. Now, on to the speakers. And when we post this podcast, there'll be detailed bios. But in brief, let me introduce our panelists today. Linda Drucker is Associate General Counsel of Schwab Co, where she manages a team of attorneys and paralegals located in San Francisco, Denver, Chicago, and Phoenix. That group represents Schwab and FINRA arbitrations and other legal matters nationwide. Linda has, in nearly 20 years at Schwab, supervised some 3,500 arbitrations and disputes and worked with hundreds of outside counsel, mediators, and expert witnesses. She serves as a FINRA non-public arbitrator and has been a longstanding member of the Securities Industry and Financial Market Association's Arbitration Committee. She was a member of FINRA's National Arbitration Committee from 2007 to 2010. Next, Christine Lazaro is director of the St. John's Law School Securities Arbitration Clinic. She came to St. John's in 2007 as the clinic's supervising attorney. She's also a faculty advisor from the Moot Court Honor Society. After graduating law school and prior to joining the Securities Arbitration Clinic, Christine was an associate at the boutique law firm of Davidson and Grunham, LLP. She's familiar with and represented many clients in arbitrations and mediations. And last but not least, Joe Peiffer is founder of Peiffer, Roscoe, Wolf, Abdullah, Carr, and Kane, a nationwide law firm with offices in 5 states. I believe he's down in New Orleans. We're up here in the Northeast where it's freezing. Joe's in a warmer climate. He's represented over 500 clients in FINRA arbitrations, ranging from individual retirees to municipalities. He's the current president of PIABA, the Public Investors Arbitration Bar Association, which is a bar association of claimants' attorneys. And of some importance to us here today, he sits on the FINRA Dispute Resolution Task Force. We'll come back to that later. He lectures frequently in FINRA arbitration and is taught at Loyola School of Law. Now, what are we going to be talking about here today? Here are some of the questions we're going to pose to the panel. As you can see, the brief history and background on the FINRA mediation program. And some practical questions. Where do the cases come from? How many are there? What's FINRA's market share, and is it growing or diminishing? What do we think is going to happen to the mediation forum over the next 5 years? Some pointed questions. Will it survive? Should it? And then we'll wrap up with some recommendations for the FINRA task force on changes that might be made to improve the mediation program, or even something as radical as getting rid of it. Time will tell. Okay, let's move on to the 3 main topic areas we're going to be discussing, and then we'll circle back and delve into them. We'll first look at the state of securities mediation today. More on that in a minute. And then Whither, look at the spelling. You know, is it going to wither, or what will happen to the FINRA mediation program after 20 years? And then last, we'll circle back to the panel to discuss where we think we'll be 5 years from now. I'll say it later, but this is my favorite part because people can disagree with your concepts or predictions, but they can't categorically say you're wrong unless they claim to be returning from the future, in which case credibility goes out the window. Now, let's get on to our first topic, the state of securities mediation. Today, we'll introduce the subtopics as we go along. But let's start with the first one. Before we talk about where the program's going, we probably need to talk about where it came from. So let's start with a brief history and some background on the FINRA program. And to do that, I'm going to lead with Roger Deitz. Roger's a mediator. He's been a mediator for a long time. He's been a FINRA mediator for a long time. And he knows from whence this program came. So, Roger?
Well, I hope that doesn't mean I'm old. Way back in the last century, you went out, and in fact, I witnessed this myself many times, and asked lawyers and experienced lawyers in securities and in other backgrounds, if they knew anything about mediation, the typical answer would be, "Oh, I know all about arbitration." And then you'd say, "Well, mediation's different from arbitration." And they would say, "What's mediation?" So those days are long since past. But as far as the NASD, now FINRA program, you have to go back to 1989. And between 89 and 93, the NASD arbitration department, there was no mediation then, engaged 2 pilot mediation programs with outside providers. These were not very significantly used. The results were not all that good, and they were dropped. And the current program really is the result of 2 things. One is experience of principally defense lawyers, I think, in the insurance industry who had started using mediation to resolve insurance, not necessarily securities-related problems. And they were finding mediation was resulting in quicker, less expensive, and actually less expensive because the legal fees were reduced because problems were being resolved at an earlier stage, but also less expensive resolutions than they were getting through the legal system. So with that impetus, basically, FINRA, still the NASD, turned to maybe this is something that might work in our field. And there's a notice to members, 95-1, where the NASD solicited comments on a proposed NASD mediation program and draft mediation procedures. And the long story and the short is that the details of this were picked up by the Arbitration Policy Task Force, a major document that, if you're not familiar with, really, even today, 20 years, almost 20 years later, merits a rereading. That was chaired by David S. Reuter, who is former chairman of the Securities and Exchange Commission. That was published back in January of 1996. And among the Reuter Commission's reports or recommendations was the establishment by the NASD of its own mediation program, and the rest is history. So I don't know if that was too much detail, George, but that's the background.
No, excellent. And that 1995 year sticks in my mind as well. I came to FINRA a few years later, and at that point it was a new mediation program, but that's spot on. Now, Christine, you run a securities arbitration clinic and mediation clinic at a law school, and we know that the clinics tend to like cases that aren't gigantic, so the students can be exposed to the full range of activities in a case. So I think would make mediations attractive. Now, there's a FINRA small claims mediation program that was launched. Could you tell us a bit about that and how you react to it?
Okay. So just a little bit over 2 years ago, FINRA launched its small claims mediation program, which is specifically for cases under that $50,000 threshold, which are basically the simplified cases, which tend to be the cases that the clinics are handling. And for these cases, FINRA developed a telephonic mediation program. So for parties who are participating in this program, FINRA will waive its mediation filing fee. If the case is $25,000 or less, there are no mediator fees either. So the program is completely free for the parties. If the case is over $25,000 to $50,000, the parties will pay $50 per hour for the mediator fees. So a few of the clinics have participated in the program, and they found it to be effective, even though the entire mediation took place on the phone. And especially for these size cases, it keeps mediation as a viable alternative. The cost of mediation really is a concern for us and for our clients because we don't want to eat up the potential amount of money that will be there for settlement for the costs associated with mediation. If parties do want to use the program, all they have to do is let FINRA know that they're interested in the program, and then FINRA assigns a mediator to the case who's agreed to participate in the program. It is important that you get a mediator who's agreed to accept either no payment for the process or the reduced fee. And then the mediator reaches out to the parties and schedules the mediation. And I do think this is a good step in the right direction, especially for small claim cases.
Okay, thanks. Now, more background, some basic questions. Where do the cases come from? For that, I'll ask myself. So I'll change seats. But there are three major sources in theory, actually two in actuality, at least as regards FINRA mediation. Pre-dispute clauses are a distinct possibility, but there are just not very many of those in the customer broker field. And in fact, there might be an issue. Many years ago, at least some officials at the commission whose staff deal with on this question, would express concerns about mandatory mediation clauses, something we're going to talk about later. So you just don't see too many of those at FINRA mediation. You do see them in you might see them in investment advisor contracts, many of which don't call for FINRA and might call for the American Arbitration Association, for example, or JAMS. But in the FINRA world, those are few and far between, almost non-existent. The more robust source of cases for FINRA come from the next two, what FINRA calls straight-in cases, or arbitration conversions. Straight-in simply means there is no existing arbitration, and one or more of the parties says, hey, look, we've got this dispute, and we're willing to mediate if the other side is. And FINRA will step in and try to broker an agreement to mediate. It's about 10% of the overall mediation caseload. So therefore, the other 90% of the mediation caseload results from arbitrations that are converted at some point to a mediation. And there's an inducement of, FINRA will waive fees, for example, for cases up to $25,000 if they're in arbitration. So if you're in a FINRA arbitration and a case involves less than $25,000 and you want to mediate, there's no FINRA mediation fee. I'm not discussing mediator fees. So, but those are the numbers, and that's typically where cases come from. Now, how many cases are there? These are good questions. And other statistics, how well do people do? If you go to mediation, the objective is to get a case resolved by settlement. What is success rate? Number of mediators. Linda Drucker, can I ask you to address those pointed questions, please?
Sure. George, interestingly, the one really bright spot is that the settlement success rate in mediation, FINRA mediation, has remained relatively constant over the past several years, and it's hovering at 79 or 80% of the cases settled. So mediation is still highly effective in that 4 out of every 5 cases in which it is used are settled. FINRA recently released some statistics for January 2015, and that's only 1 month. But surprisingly, those statistics show that the settlement rate jumped to 91% of the 46 cases that were mediated through FINRA Mediation Department in January of this year. But if you look at the larger picture, there are some observable trends that are disturbing in terms of a decline in the number of cases being mediated through the FINRA program. So in 2012, there were 572 cases mediated under the auspices of the FINRA Mediation Department. That number dropped to 482 in 2013, and it further declined to 431 in 2014. So you see an 11% decline from 2013 to 2014, which may in and of itself not be significant. But when you look at the drop over the course of 2 years, there's nearly a 25% decline. 24.6% to be exact. So that is a concerning trend. The question is, what are the causes of this decline in the number of cases being mediated through FINRA? Is it simply a symptom of the fact that fewer arbitration cases are being filed? I mean, we know that there's been a tremendous drop of almost 50% between the number of arbitration cases filed in 2013, 2014 versus the number at the height of the credit crisis in 2009 and 2010. So a decline in the number of cases mediated would be, natural and expected. Or are the parties simply using mediators less frequently than they did before? Maybe parties are settling cases directly, but I suspect that's not the case. The final possibility is FINRA's market share of the number of mediations, total number of mediations declining as parties go outside of the FINRA process to other dispute resolution providers and individual mediators. And that's something we're going to talk about in a little bit, but I think that's a real possibility. So one other thing I wanted to point out is regarding the number of cases closed during mediation. You're also seeing a decline there. In 2012, there were 776 cases closed as a result of FINRA mediation, and that number declined in 2014 to 551. So once again, if you compare 2014 with 2 years prior, you have a drop of almost 29%. And once again, we need to ask the same question. Is it a result of just fewer arbitrations in general, or is there something else going on?
Yeah, my own take, having been Director of Arbitration for many years, at a high level, the mediation caseload, again, 90% of the mediations start out as arbitrations. So the mediation caseload will follow, to a great extent, the arbitration case filings. Or in plainer terms, the last several years, the number of arbitrations filed each year has been going down, And one would expect the number of mediations, since most start out as arbitrations, to also go down. But there are other forces at play. There's no question about that. Which brings us to the next topic. FINRA's market share and competitors, a bit of a touchy topic. But let's start with Joe. He represents investors. What are you seeing there?
Well, I've got to say that, pardon me, I very rarely will go through FINRA for my mediation because I will have or mediators that I have found that I trust, and that more importantly to me, that the respondents trust. And I think those mediators are in such high demand that they are not really working within the FINRA mediator system any longer, which involves a little bit reduced fees and things like that. So from my perspective, I very rarely use FINRA mediation process. I do use mediation for my FINRA cases. It's just that I don't generally go through FINRA for that, because I think for the size of cases that we hope to bring, it doesn't matter as much how much the mediator costs if I think he's effective. And so that has been my experience. For the smaller cases and where you have to be more cost conscious, I've also found that the mediators that I use repeatedly and that the respondents use repeatedly will work with me on that too. So I just hadn't seen the benefit really of going through FINRA mediation unless you are close to your hearing date and you can get a cancellation fee waived or something along those lines.
Let me ask a follow-up question. Roger, I'm going to ask you one as well, so stand by. But Joe, at a high level, do you think the competition comes from other dispute resolution providers like AAA or JAMS, or from mediators?
I think it comes from mediators.
Okay, Roger, here we go. So hypothetically, I don't want to ask you what your practice is, but hypothetically, as a mediator, how do you react to that?
How do I react to what?
To the idea that, in large numbers, parties that might otherwise end up in a FINRA mediation are directly going to the mediator instead.
Well, I'd ask you to, I don't care, to tell you the truth. Well, I do care, because I think that FINRA mediation is important, and I'll come back to that in a minute, and that it should exist and it should not disappear. But the reason for that is different from the original reason that the program was created. The original reason is nobody knew what mediation was. It needed to be promoted. It needed to be, the pump had to be primed. People had to have experience with it because they had none. They had to have successful outcomes, which eventually they did. A cadre of good mediators had to be established, which it was. And once all of that happened, the original and FINRA threw an enormous amount of resources, millions of dollars, into that effort. But once that was accomplished, George, the parties made relationships with mediators. They didn't need FINRA to make that connection anymore. I agree with Joe that sometimes you need to have you're using the hearing dates. And as we all know, there's a FINRA rule that if you go through FINRA mediation, that the arbitration is then automatically postponed. Going back to the history, there was a time when, before that rule was adopted, that you had to ask the arbitrators for permission to postpone the hearing, and arbitrators weren't doing it. Parties were in agreement to try to settle the case, and the arbitrators were saying, we've reserved these dates, and you have to come in and see us. So those days are past, of course. So to answer your question, hopefully, the existence, why the FINRA mediation program, I would say is to expose mediation to this diminishing number of lawyers who don't know about it anymore. But the regular players know about it, have found good mediators, and really don't need FINRA to administrate it. There's one other thing, George, you haven't touched on, which was there was a time, long since past, when the existence, and you know about this, I'm sure, the FINRA mediation program was a benefit to FINRA, then the NESD, because in those days the NESD dispute resolution program showed a profit because you're able to keep fees from the arbitration that you didn't have to spend on processing and arbitrators because cases were getting resolved at an early stage through mediation. Those days are gone too.
Oh, yes. Now, speaking of Roger, I, of course, forgot to introduce you, Roger.
No, it's okay.
No, our audience know who you are. Just say you're a famous mediator, but he is. He's been a longtime mediator and arbitrator and successfully resolved over 1,750 mediations involving all kinds of securities and related matters. Of importance, Roger received the FINRA AAA Office of New York Court Administration Frontline Mediation Award, which I know is not easy to get. He's been he served on FINRA's National Arbitration Mediation Committee. In fact, I think he was the first chair of the mediation subcommittee.
They actually changed the name. Before that, it was just the National Arbitration Committee.
There you go. So everyone, you're taking something away from this program you probably didn't know before. Roger also serves on the Board of Editors of the Securities Arbitration Commentator, and pretty much every year, the last several years, has chaired the New York City Bar's annual Hot Topics program on securities arbitration mediation, as he's doing again this year in May. Okay, sorry about that, Roger. I apologize. Okay, so having discussed market share and where the program came from, let's get into where we think it might be going. And for that, we move along to our next slide. Now, this play on words aside, we're going to do this part a bit differently. We're outlining some possibilities of what may become or should become of the FINRA mediation program. Here are the obvious ones. You leave it the way it is, which is a full-fledged program with rules, mediators, and staff. Or you scale it back, perhaps to a mediator vetting and referral service, or you eliminate it. It's ineffective or perhaps unneeded or a duplication in today's dispute resolution world, or some combination of the above. So for this one, I'm going to call on each panel member to address not necessarily every point, but your thoughts on where the program needs to be or what it needs to become. So let me begin with you, Joe, as a representative of the Customers Bar.
Thank you. Sorry for if there was a little background noise. I'm actually conducting a mediation for a FINRA case right now as we're doing this podcast.
It's also a first.
Yeah, exactly. Exciting. Where do I see the program going, and where should it go? Is that the question?
Well, what's going to be, what should happen here? What will happen will be the next segment, but what should happen?
Well, it seems to me that Roger's point was exactly right, that this program is still needed for people that are not used to securities matters. I think that the arbitration system, at least is supposed to, and I think this happens less and less, and probably should happen less and less, but it's supposed to be able to accommodate pro se plaintiffs. And those are the folks, the pro se plaintiffs, the smaller claims people, and the folks that just don't know too much about securities arbitration, where I think it really is still needed and will be helpful. I think at this point we've got a good cadre of mediators who can mediate a FINRA dispute, and they do or do not go through FINRA mediation, as I sort of discussed before. But I think the reason that I think the program should stick around in the primary constituency for which it should serve are the people that either are very unfamiliar with the forum, are representing themselves, or have small claims. I think it makes sense for those folks, and I think it'd be doing a disservice to them if it was completely eliminated.
Thanks. Let's go to the other side. Linda, thoughts?
Well, I agree with Joe that the program should be continued in some form, maybe scaled back a bit. To a certain extent, it's a victim of its own success. But I think it does offer some benefits. And I think you need not only a bare bones vetting and referral service, but you do need some case administration resources for it to be continue to be successful. Maybe those will be more limited, but you do need some oversight of the program. And I think the program is useful for finding mediators in states and locations where even sophisticated parties don't have a cadre of mediators on call, and the itinerant mediators aren't necessarily able to travel all over the country, and you can't necessarily get one of those people to travel to a remote location in a 30 or 60-day window of time. So that's useful. I agree its primary utility is in the smaller cases, and cases where it's just not economical to pay a mediator to fly in or to pay a mediator a $5,000 or $10,000 daily fee. I also think it's a useful training ground for new mediators. At some point, this generation of mediators that we all use regularly, 300 days a year, they're going to move on, and this could be a program that generates the next generation of mediators. And we did refer earlier to the benefit of enabling parties to avoid postponement fees if you use the FINRA mediation program as opposed to going directly to a mediator. There's another benefit, which is that the mediator in the FINRA program doesn't have to do the collection efforts himself. FINRA bills the parties for the cost of the mediation, and FINRA pays the mediator. And I once had a mediator approach me and say, Linda, please, I'll do this mediation for you, but please do it through the FINRA program because I'm a little worried that the other side isn't going to pay my fee, and I want to be sure that's taken care of. So it does have that benefit of getting these mediators out of the collections business as well.
That's an excellent point. There's no question in my mind, having been at FINRA all those years, that the program helps insulate the mediator from some of these occasionally difficult problems with collection or beyond that. Scheduling issues, complaints about party behavior. There's no question in my mind as a mediator, you might want some intermediary between you and the parties. All right, Christine, thoughts?
I think the program really should stay more or less as it is now in terms of size. I think the mediator vetting process is important. Again, for the experienced attorneys, it's not as important, but for the new attorneys or those who are in this forum for, as one-timers, it's nice to have a neutral source for a mediator suggestion. And even for the experienced attorneys, when you're looking for 4, 5, 6 suggestions, it's nice to be able to go to one place and get uniform information about the mediators so that you can compare the backgrounds of the mediators and find the one that's going to be right for this case and have that information all put together for you by FINRA. With the rules, even for experienced attorneys, not having a set of rules in place, when things are going well, that's fine, but in those cases where things don't work out, sometimes it's nice to have the rules to fall back on, and to be in a forum where you have mediation rules in place, I think that's a good thing. And again, for the new attorneys in the field and for those who are here for the first time, for handling a one-off case, to be able to know exactly what to expect coming into the forum, I think is a good thing. And on the claimant side, because we all know that the firms are going to be the repeat players, so this is really about protecting the investors and their representatives. As far as the case administrators, in addition to just coordinating with the arbitration side of the case, I've also used the mediation case administrators to reach out to my adversary to feel them out about mediation, about their willingness to mediate, so I didn't have to do that myself. And it's nice to have that third party there to actually propose mediation to the other side. And you also have FINRA sending out at the very beginning of the arbitration case all the information about mediation, suggesting mediation from the very beginning, and making sure everybody is thinking about mediation throughout the process of the case.
Thank you. And FINRA will not charge for that service. The service of reaching, when one party says, look, I'm willing to mediate this case, they will not charge for reaching out to the other side and, as I said, trying to broker the agreement. All right, Roger, I'm not forgetting you this time. So you heard what the others said. You're a mediator. What are your thoughts?
Well, who is the constituency that FINRA serves? And there are a number of constituencies, but I think paramount is the integrity of the American capital markets, which I think is tops in the world. And one of the reasons that people from all over the world are willing to invest their money here in the United States is that they believe they got a fair shake if there's a problem in its resolution. And mediation is part of the options of resolution. So I think that the FINRA mediation program must continue, should continue, and must continue. The question is to do what? And one of the things I think is paramount, I'm going to pick up on, Linda, something that you said, which is where's the next generation coming from? I couldn't agree with you more. And beyond that, there is a total, almost total, in some respects total, lack of diversity in the pool of mediators, and that's wrong. And FINRA and the industry and Joe, the plaintiff's bar, Piaba, should really put a little bit of extra efforts in, and FINRA can be the convener for this to help you out, to bring in more women as on-demand mediators, more minorities as on-demand mediators, more people from ethnic backgrounds who represent the investors and the industry, which is not the case today. So I think FINRA can occupy a very important role there. Hasn't done it yet, but perhaps it'll decide to do it. And then beyond that, as an advocate, as Christine just said, to those people for whom mediation is unfamiliar, to help bring them into the process for their own good. So I think that there's a place and a need. And I wouldn't be complete if I didn't say a couple of things that, and you said it at the beginning, George. And Linda said this also. I think that it's a victim of its own success, and that success, to a large degree, rests on the NASD's commitment, dollar commitment, but also the physical efforts, the time and energy, as you said, of Ken Andrzejczyk, who headed this thing from day one, and also an array of administrators who I think were non-pareil and reported back to me when people were dealing with the arbitration side and the mediation side. There often would be a difference, and sometimes a big difference, of the service that they got. And notably, people maybe have forgotten this name, Conrad Shee. He was there a million years ago, and more recently, Ed Siaga. I cannot tell you how many in the industry and the claimant side were benefited by Ed bringing problems into resolution and people avoiding perhaps worse results on either side out of the arbitration process. So yes, I think there's an important role to be played. Maybe change, but important.
And it sounds like we may have our first two recommendations for the FINRA task force. It seems like there's a consensus the program should continue more or less in its present form, and the second, that it should be a convener or vanguard on recruitment, especially for women and minorities. So we've got two already, I think. Okay,
that takes a commitment, a difficult thing to do, and a practically difficult thing to do. If you're a party, if you're representing an investor, or you're representing a brokerage firm or a financial advisor, and you've had success with a small group of mediators in past resolutions, why would you go elsewhere? So it's something that's got to be, it has to happen, but it's got to be pressed and sold.
I absolutely agree. Well, let's move on to our final section, which again is my favorite part because people can't say you're wrong; they can just disagree. But we've talked about what changes should be made. Now we get to what is actually going to happen, what we think will be happening. Again, I'm going to call the roll in slightly different order, but the panelists will give us our predictions for where they think we're going to be 5 years from now. And I think to keep us moving along here, I'll ask you as you go along to identify what you might think would be recommendations to the task force. Now, not to put them on the spot, but to put them on the spot. Joe, you're on the task force. So I guess the first high-level question before we spend a lot of time on this, do you think it would be receptive to recommendations coming out of our podcast today?
Absolutely. The task force is receptive to recommendations coming out of any knowledgeable person, be they an arbitrator, a mediator, a participant in the forum, an investor, a claimant's lawyer. We want to hear from everybody. And so I'd like to encourage even listeners of this podcast to make their suggestions to the FINRA task force, because we've got a lot of really smart people, a lot of people a lot smarter than me, frankly, on the task force. But we don't have, everyone. And so we want your suggestions, and we welcome them very much.
Thank you, Joe. Along those lines, the task force published on the FINRA website an initial list of areas that I'll be looking at. And one of the major groupings is indeed mediation. There are two bullets underneath that. One is a suggestion that it will consider to encourage greater use. Sounds like we're all behind that here. And the other, which is more interesting, is whether to have sort of mandatory arbitration, either opting in or opting out. So as we go through where it might be, I'd ask the panelists to touch on certainly the opt-in or opt-out on mandatory mediation. And if you forget, I will prompt you. So let's begin. Joe, you have the floor. So, what do you think we're going to be? And I know you're not speaking for the task force, but speaking for yourself, what changes should it make?
Well, I think that actually we're kind of on the right path here. Again, I hate to just echo what Roger said, but it's not often I always say Roger's right, but he's right on this issue, I got to say, and he's dead on who I think FINRA should be serving, and it seems like they're moving in that direction with these smaller case phone conferences. I've not had any experience with them, but it sounded like from Christine that they were going at least okay and fairly well, maybe in some instances. And I also agree with Roger that the second thing that has to be done, and this is where FINRA is going to have to spend some money and spend some time and thought, is to how to get the next generation of mediators, and not only to how to get them and how to train them, but how to make them look more like our clients. And I think that's something that I'd like to see in the next 5 years myself.
Hey, thank you. Linda?
Well, I think one thing that should be explored is the use of technology. As a broker-dealer on the West Coast with many mediations on the East Coast, it often takes us 3 days. When we commit to a mediation, we often lose 3 days of time, a day of travel time on either end and the mediation day itself. So it's not inconceivable that in 5 years we'll be doing mediations via FaceTime, video conferencing, other forms of technology, so that we're certainly doing them already by telephone conference. And those can be very, very effective in, smaller cases. But we need to figure out a way, if you're doing it via telephone conference or video conference, how you can do the presentation, do a detailed PowerPoint, make that, make the opening statements really available as opposed to just a telephonic, sort of the individual sessions with the parties. And I think we do need to focus on a new mediators training program. I mean, one of the concerns I have is that when I looked at the requirements to be a FINRA mediator, you already have to be a very experienced mediator to get onto the FINRA mediation roster. So I know many attorneys who, including people in these diverse populations we're talking about, who want to become mediators, but they can't even get their foot in the door. So I think on these very small cases where FINRA is charging $50 an hour and it's being done telephonically, FINRA has to recruit people that are, they're not necessarily skilled mediators already. There needs to be an opening for experienced lawyers who don't have a long resume of 100 mediations or even 10 mediations to their credit. And I think I like the idea of having to opt in or opt out. It should sort of be like those online dating things where if both people click that they want to meet each other, then they're connected. So if there should be forms sent out at certain points in the process, and, maybe at the beginning and then also 90 days before the hearing, something of that nature, where the parties check whether they're open to mediation, and if both say yes, a mediation is scheduled.
Let me circle back to Joe. What about that opt-in or opt-out idea? I mean, I'm not asking you to divulge things you shouldn't from the task force's deliberations, but from the bullet, it seems there's someone proposed for the task force to consider essentially mandatory mediation with the right to opt out, or some kind of an opt-in system. So can you share any insights with us or reactions that you might have?
I think what I can say about that is that the task force is considering that. Obviously, it's on the bullet point, and that it's been assigned to a subcommittee, and they're working through the issue. And I don't really want to say what my position is on that in this call, because it's a specifically enumerated task force topic. But I do welcome any input from anybody else.
Okay, and that's perfectly fair. Didn't mean to put you on the spot.
No, it's okay.
And I'll just react to one of the issues. I'm chairman of the Board of Arbitration Resolution Services, which, of course, is an online provider. And I think Linda hit around in the head. The future is going to see incredible advances in technology. We're seeing them already. And the idea that parties will be sitting, I put quotes around that, but sitting in a conference room, even though they're in distant cities, and appearing to be looking face-to-face, probably in 3D holograms. I'm sure that's coming soon, to the point where you'll be able to judge reactions, body language, and also the idea that for some really small cases, you might just try to match a bid and offer an acceptance. It's definitely coming. Telephone mediation, I think, will be viewed years from now as a transitional technology, the same way we look at fax now as a bridge or transition to email and other forms of social media. I will get off my soapbox and turn it over to Christine. Where do you think we're going to be? Any ideas for the task force?
I agree that mediation really is important for the small cases, especially the simplified cases on the papers. In those cases, the customer doesn't get to testify, so they don't get to tell their story. And the big issue in those cases is they usually don't feel like the other side understands what happened to them. And this can be a problem in settlement and can lead to impasse in the negotiation. So the opportunity to be able to speak to the other side and explain what happened to them sometimes can be all that it takes to actually get to the settlement. And, telephone mediation is okay, and I think it is the first step in that process. But I think, we're at the point in technology now where video conferencing really should already be happening. And, we use it in the classroom to bring in speakers, to bring in distant students, and it should be easy enough to evolve the mediation process at this point so that we can be doing mediations at a relatively low cost, no more expensively than the telephone mediations, using video conferencing technology. And as far as a recommendation to the task force, for the small claims where there are no fees right now, I would recommend extending that up to the $50,000 mark and making mediation mandatory for all the simplified cases with an opt-out for the claimant. So that claimants have the ability to utilize mediation in those cases if they wish, but have the ability to opt out if they don't want to.
Similar to the old optional public panel rule.
Right.
Very similar concept.
George, I need to respond to that. I don't think the industry would be in favor of that of that unilateral opt-out. There are definitely cases where, mediation of any form, even telephonic mediation, requires a commitment of time and resources. And there's still going to be a group of cases that, the industry looks at and says, this is a frivolous case, or this is a case that there's no liability. And I don't think it should be mandatory. The parties should have some amount of free will and free choice in deciding whether to mediate.
I'll exercise the moderator's prerogative. I haven't weighed in on too many, but yeah, my reaction to a mandatory mediation. I mean, it's not like an arbitration, it's mediation. The case doesn't settle, obviously, if the parties don't agree. So compelling an unwilling party to mediate, to me, smacks of wasting time and money. Now, I'm sure there are nuances to it. We certainly won't have time to talk about it today, but my first gut reaction was, I'm not so sure about that. Roger, I don't want to forget you again, so you get the last word on this.
Well, first of all, I agree with Linda and with you, because there are disputes and they are not infrequent where for one reason or another, having nothing to do with the merits of the claim, but everything to do with the effect of the litigation on an industry position or a position with employees or a position with competitors, where one party just does not want to settle. They would rather spend the money and risk the possibility of not prevailing. And in doing that, they've sent a message out. And so mandatory mediation, basically, I completely agree with what both of you have said. I'm not in favor of it. Now, having said that, I think when people do get together, oftentimes the beginning of the day, this problem will never get resolved, and at the end of the day, lo and behold, it is resolved. So I'd encourage people to sit down with each other, but if they've got some other reason not to do it, you got to respect that. So that's number one. And number two, as far as FINRA, going forward, this is not going to be a revenue producer, and we haven't talked about that. So internally, where is FINRA going to get the political will to spend money on this thing? So that's something that, and is there a benefit? Some benefit. It doesn't have to be a benefit to FINRA. It could be a benefit to the integrity, as I said before, of the capital markets of the entire industry. But going forward, is I don't see the administration of mediations being profitable, at least not for FINRA. But it can, if it chooses, do a number of different things. One of the things that interests me is the creation of innovative dispute resolution processes for certain disputes. For instance, if you have product cases, if you have a bad broker situation, if you've got a number of cases and you want to dispose of them, to create a process that's efficient and gets the job done, it's something that FINRA might have a place convening or giving options to people. Another thing we haven't talked about is MED-ARB, which I think has got a great potential, where a case starts as a mediation. Both sides want to resolve it. They don't want to spend the money to have a full-scale arbitration if the mediation does not end in a resolution, and then let the mediation end in an agreed process, where going forward it's an agreed process rather than a full-blown FINRA arbitration, and maybe FINRA's got can have a hand as being so to speak a think tank in exploring some of these innovative and creative options. And the last thing is, what is mediation? We haven't even talked about that, and there's a real debate. And what goes on in FINRA mediations, to some people may be mediation, and to other people may not be mediation. But that's maybe, George, a topic for another day. Long story to short, to finish that, if you only look at the four corners of the problem, you're probably not reaching, in many cases, not all cases, but in many cases, the reasons why people found a lawyer in the first place to bring a claim, or are defending the claim. So that's something else. Oh, and we also haven't talked about employment mediation, which is a whole nother issue, and mediation, the tension between the firms and their registered employees. And
there'll be more podcasts.
I've seen instances where the employee has got so much clout that the employee is making the decision rather than the firm. So,
food for thought. Okay, it's time for us to wrap up. It's been a great panel discussion. I'd like to thank our panelists, SAC, for a great program. Christine, Joe, Linda, and Roger, great job. Thank you, audience, also for listening. You can follow SAC and some of our panelists on social media. Look for our next podcast coming later this spring. We have plenty of topics to think about. So thank you for attending. Visit our website at sacarbitration.com to see additional program offerings. You can sign up for notifications and, of course, follow us on Twitter. That concludes our program. Thank you very much and have a great time.
George, thank you.
Thank you.